Right, I think that we'll get started then. Good evening, everybody. My name's Eléonore Berthelsen, and together with Jennifer Youngs today, we are going to be presenting this webinar, which is about the private law children's system, in particular intractable disputes, the obstacle course of private law children cases, and whether or not recent guidance and new initiatives will make things easier for us going forwards. This is a seminar within our family law webinar series, and without further ado, we will simply launch into today's webinar. So we're going to be considering intractable disputes concerning children and how the current system and pilot schemes are seeking to address this. We say that it's timely, not least because last week the Public Accounts Committee published a report on improving family court services for children, in essence, because in their view, children and families are being let down by unacceptably long delays in the justice system. And there were three issues which the committee came back to repeatedly. So the experiences of children, how the needs of victims of domestic abuse are addressed, and also the backlog across the system. Of importance to anybody who practices within this area, the Pathfinder Pilot was repeatedly referred to as the way to proceed in the future. In fact, there didn't seem to be anything else really that was mentioned except very much in passing as an alternative to this. And whilst the rollout appears to be slow, and I should say that for any viewers in North Wales and Birmingham, Dorset, you may not feel this is very relevant to you, please do persist, because there are some parts of this which are still going to be relevant to you. We will end up with a system in which it seems pretty much everybody is going to be working within the system in the next year or two, if the powers that be get their way. So it's an important clarion call, that report, because they also ask for clarity about how the government is going to resolve a number of issues which would prevent this rollout. So, for example, the shortage of district judges and social workers within CAFCAS. Strangely, at present, nobody seems to be very interested in seeing how earlier legal advice might be part of this picture. But as Jennifer will discuss, there is still very much a role for that within this system. And of which more anon. So I'll hand over to Jennifer to explain exactly what it is that we mean when we talk about an intractable dispute.
Yes, so we have defined intractable disputes as essentially any case that's going on for longer than you would want it to, and where obviously that delay may prejudice the welfare of the children who are the subject of the application. Some examples that we have given is where cases where a child is refusing contact, but for a reason of either having been the subject of alienating behaviours or for any other reason. Domestic abuse, repeat applications, and of course just the delay that unfortunately at the moment is somewhat inherent in the family justice system more generally. And just pausing there, when we're talking about the delay, it's not just in the cases getting listed and in the volume, but also other things which might make things take more time. So, for example, of particular interest to anybody looking at the Pathfinder model and its scope for use in the future, there is the problem caused, for example, by Section 7 reports routinely taking far longer than they ever have to be completed. I do know that at a point in 2023, there were areas in the country where CAFCAS were just saying, we can't do Section 7 reports, we're not going to take your cases on. So delays, not just because of volume, but also because obtaining important reports appears to be taking longer than it might have done at any time prior to the pandemic. Yes, I think certainly there are definitely still areas where it's looking at over 20 weeks or so for Section 7 reports by CAFCAS. Certainly, I've come across that. I don't know if I had a case where I was basically told, no, you're not having one. Go away and think of something else, and that was quite interesting because the local authority also refused to assist us. So we're going to move on to discussing alienating behaviours, which is, I suppose, the more traditional way of thinking about an intractable dispute. So a dispute which is taking very long, not because to resolve, not because of problems with the system, but because of issues arising in the case. Yes, so I think what we're going to look at is not the definition of alienating behaviours in any particular detail, and there is a lot of detailed guidance in that document that the Family Justice Council set out in December of 2024, but rather what to do if you have a case where this is what is being alleged. Because much of the focus of this seminar will be how you effectively case manage when you have cases that involve these issues, and coming at it from that direction rather than looking at the particular substance of what is alleged. That is, of course, a very detailed and relevant document that you can look at, and I'd recommend you look at in respect of this issue. The definition is, though, of course, important when working out if you need to case manage for allegations of alienating behaviour, and that is what the court will be looking at when it's gatekeeping and allocating cases, and that's what's set out there. The third point is particularly relevant. It's when the other parent is engaged in behaviours that have directly or indirectly impacted the child, leading to that reluctance. So there has to be the behaviour and the causation, which then distinguishes alienating behaviour from just the reluctance, resistance or refusal of a child to have contact with their parent, which can be for a variety of potential reasons. So the focus of the consideration on issue and then at case management stage is going to have to be the definition and whether or not you have the evidence that would establish those three limbs of the test that is set out in the guidance. This is the flowchart that's in the guidance document from December of 2024, which we have distilled down into hopefully the more straightforward list of chronology of where the case may be going if you have those allegations. When the case is issued, if there is on the face of it evidence of alienating behaviour, the matter should be allocated to a judge. The guidance is, though, however, very careful to say that not all cases where there are allegations of this nature will be allocated away from the magistrates if that's where they've been sent initially on issue, and that the matter will be kept under review at all case management stages to ascertain whether or not there is that initial evidential basis to establish alienating behaviour. But that is what should happen on allocation. The matter will then come before the court for a case management hearing, and the court will again consider if the elements of alienating behaviour can be established. The court then considers if allegations of domestic abuse have also been made by parties to the case, and the guidance is clear that the initial focus of any fact-finding exercise will be those allegations of abuse, even if a fact-finding may also encompass alienating behaviour. The court will consider whether or not a fact-finding is then proportionate and necessary, and if it is, it will then proceed down the route of having a pre-trial review and then a fact-finding. The one point that is made very clear in that guidance is that the expert assessment comes after the fact-finding exercise, so you're not asking experts to make findings of parental alienation, as I think has sometimes been the case.
Well, yes, but we are, I think, now extremely aware of the case law, which tells us that experts can't diagnose parental alienation. It is not a thing.
Yeah.
So I think we'll move on to the next slide.
Yeah.
So, which is domestic abuse and how that is now being factored into the system.
Indeed, and I think the theme that is consistent throughout both the discussions that we have had when preparing this seminar about both alienation and domestic abuse is the need to be alive to what your client is alleging, the evidence they have in support of those allegations, and what then those allegations actually constitute. Because if there are allegations of either domestic abuse or alienating behaviour, there is going to be a need to grapple with the issue of fact-finding at a very early stage, because one of the things that can cause delay is if that doesn't happen, and if you proceed off down a path that involves being a Section 7 report or similar, where there are allegations coming from usually both sides, none of which have been determined, and where the court isn't going to have a factual basis to make an assessment of risk, and where that CAFCAS officer isn't going to have a factual basis for an assessment of risk. And that, I think, in both of our experience, is an example of when there can be delay that could perhaps have been avoided earlier on if actually parties had acknowledged the need to have that factual basis early on, rather than proceeding off and trying to avoid
Fudge it?
that potentially. Yes, I think that's
The fudge.
certainly, yes, that's I think Eleanor put that very succinctly there. Yes, so sometimes that's just not going to help, I think, is what we're saying in the long term.
We would say beware the compromised factual matrix, because clients need to be very clear that if that is the route that you're going to go down, in order to avoid a fact-finding hearing, you're going to miss out on the nuance which you would have from a judge giving a judgment and evaluation of all the evidence, but also they need to understand that that means abandoning a lot of allegations that they have made which are not going to be pursued, which is something that people often find very difficult to do. And even if they do it in the moment of the compromise at the hearing, there are problems that can arise, often do arise in my experience, subsequent to that, through people perhaps psychologically finding it very difficult to accept, because they think, yes, but that happened to me. And it causes more problems further down the line, which can also cause delay.
Yes, because I think the reality is that you may then be in a situation where you have a client who is giving instructions based on what they again psychologically believe has happened to them, which may indeed have happened, without having that factual finding before the court. So it's then not only very difficult to coherently put forward your position, but also difficult to manage that going forward. So I think that is certainly one of the things we would say is that it's important to work out if a fact finding is indeed necessary, and sometimes it may be, even though there is a push sometimes from the court to see if the matter can be resolved. And of course, I'm sure all those watching will be very familiar with the matter that I just very briefly summarised on the slide, and K&K, of course, made clear that fact findings must be necessary. I think the question is when that is indeed the case, and there may be cases when it is necessary, even if there is a push for that not to happen. The other thing that's just been set out on that slide is the CAFCAS guidance that was issued in January of this year, which again, I'm sure everyone is more than familiar with at this stage. That is interesting because it makes very clear that CAFCAS officers must provide recommendations based on allegations, particularly of domestic abuse, that have been made in cases, and undertake risk assessments, and based on those allegations. Of course, as we all know, CAFCAS officers cannot undertake fact-finding exercises, and therefore, again, without that clear factual basis, that may actually be a difficult thing for a CAFCAS officer to do without straying into matters that are outside their remit. And I think one point that's particularly worth making is that if you are representing a parent who has made allegations of domestic abuse and have on the face of it been factored into a risk assessment by CAFCAS, it may not benefit that parent, again, to not have a clear factual basis, because that CAFCAS officer will likely be cross-examined at any final hearing about the factual basis for their recommendations. So again, it's of benefit, we would say, to any parent in a case to have that clear factual underpinning before CAFCAS get to that stage of doing a risk assessment. And again, I think that's something that Eleanor would echo.
I think that there's probably going to be in the future a bit of institutional friction between the way that CAFCAS consider the issue of domestic abuse as social workers effectively, and the way that lawyers do in the context of how justice is rendered and how facts are found within a court setting. It doesn't seem to me at present that there's a particularly good way of reconciling that aspect of CAFCAS's domestic abuse practice policy. But we will be discussing that further in the context of the Pathfinder pilot when we get to that.
Indeed, I think a lot of the reforms have been quite rightly trying to ensure that the family justice system is taking into account the experience of abuse and is trauma informed, and it is acting appropriately in accordance with all what is now known about those things. But I think fundamentally in an adversarial system, that's always going to be tricky, and that's what we're going to turn to very shortly.
So I'm going to turn to some of the ways in which the system, as we currently have it, acts to try and flatten the path effectively. And I'm going to turn, first of all, to possibly a surprise subject, which is the question of costs. I I've headed this discouraging spurious allegations, and I've cited there a case called Re that was decided earlier this year. And the reason why I think that this is an interesting proposition and something to consider is that following this case, at least anecdotally, it appears to be something which judges are more readily prepared to consider, not always at the instigation of the parties, when looking at cases at the fact-finding stage. So costs in private children law proceedings, not always a very popular thing to bring out, but in fact the family procedure rules do provide for costs order to be made within them. The court can make a costs order as it thinks fits at any time, if it thinks it is just. That's in the family procedure rules, it's in part 28. We all know that the general rule that costs follow the event is disapplied in private law proceedings, but there are still procedure rules relating to costs which do apply. Rather irritatingly, part 28 of the family procedure rules says, oh yes, and then these relevant bits of the CPR apply, but instead of just telling you which bits apply, you have to go back to the CPR and take a red pen to them and just delete the bits that don't apply. So what I will do to shortcut this, the limited time that we've got today, is to say that CPR 44 applies with some important modifications. Expressly, what's expressly disapplied within it is the rule that an unsuccessful party will be ordered to pay the costs of the successful party. That it doesn't work like that. And it also sets out, CPR 44, some of the things that the court takes into account when deciding what costs order, if any, to make. And it has regard to all the circumstances of the case, including conduct, whether a party has succeeded on all or part of their case, any offers to settle. So effectively, it is looking at litigation conduct. The reason why Re is such an interesting case to me is because it is a recent exposition of how family courts in private law children cases can make costs orders in an appropriate case. It's a useful citation to have because it distills all the law that you need to know within it, all the most recent authorities and the most important principles to be drawn from it. And importantly, what it says is that exceptional circumstances, which is the discretion the court retains, circumstances where a court can make a costs order in family proceedings concerning children, includes cases in which a party has been guilty of reprehensible or unreasonable behaviour in relation to those proceedings. And there's no distinction between public and private law proceedings, no difference in principle between fact-finding hearings and other hearings, and also it matters not whether or not a party is legally aided. In Re, the respondent to the cost application was legally aided, and it was a case, a scenario which may be familiar to many people here. Allegations of abuse had been made during proceedings for child arrangements orders, and at a later stage within those proceedings, the mother made further allegations of abuse which were of an altogether different character and seriousness than what she had previously advanced. And the judge at first instance at the fact-finding hearing made some findings of abusive behaviour against the father, but those more serious ones, which had sort of taken the case into a very different category of seriousness, none of those findings were made. And I should say that the more serious allegations of abuse were that the father had sexually abused the older children and handed them over to a paedophile sex ring. At the conclusion of the fact-finding hearing, the father applied for his costs and the application was refused. And the matter then proceeded to the Court of Appeal. And the father's appeal was allowed in part. In essence, what the Court of Appeal decided was that the starting point, that these were proceedings where both parents had made cross allegations, was an inadequate reflection of the true position because of how much those new allegations had changed the nature of the case, extended the amount of resources that then needed to be applied to get to a fact-finding hearing, and also delayed things very considerably. So the Court of Appeal decided that the judge was mistaken in treating the fact that he made some findings against the father as a reason for making no costs order at all. And effectively, what we're left with is the ineluctable point that this mother's litigation conduct had been reprehensible in terms of how she pursued those specific allegations that were clearly much, much bigger, much more serious, some might say grotesque, by comparison to what she had started off with. I suppose that there are a number of points which arise from this. I mean, first of all, I think it's quite an interesting exposition of how at some points judges may now be tempted to say, well, look, are you really sure that you want to pursue these? Because there is a risk at the end of this that somebody might come after you for your costs. And we know, of course, that the imperative of the family court is very much to enable people to make allegations if they are concerned about the safety of children, that they need to be able to do that. And that's one of the reasons why you don't normally have costs orders in private law children proceedings. One of several reasons, I should say, not the only reason, but it's important that people feel able to put their case where the welfare of children is concerned. But I suppose that potentially it does discourage the sense that some of us, many of us in fact, may have had in cases of the making of allegations sometimes feeling like a bit of a free-for-all, where you think, okay, all right, well, we have all these allegations, okay, well, we're going to have to trudge through them, what evidence is there, and look at Scotch schedules and go through all the rigmarole, which can sometimes take a very long time, but then people wanting to put in additional statements because there was something where, actually, do you know what, I had something more to say about that. It can be a very long and drawn out process, and perhaps this is a way of encouraging people to, from the outset, think about things in a more analytical way and making the system actually work by sticking to the rules, I would suggest.
Yeah, it's interesting, isn't it? Again, that a lot of the updating guidance and new pilots are focused on ensuring the system is fair and is not traumatic for those who've suffered abuse. I can see that again is a problem with the inherent in the adversarial system, and that you can entirely see someone making an argument in an interim hearing saying, well, if you pursue these allegations, I may well come after you for costs, which in accordance with that case law is entirely appropriate and something that wouldn't be criticised, I don't think, by any judge. But it is interesting how it fits in more broadly with that broader guidance. I don't have an answer to that problem. I just think it's an interesting.
Well, I think perhaps it all lies in how you draft that letter. There's I think some correspondence which gets sent is sometimes astonishing in its aggression, and that's without people throwing around the prospect of costs. But I suppose that there is a question as to whether or not an inappropriately aggressive letter couched in terms which are wholly unfair and straightforwardly threatening amounts to litigation conduct which is reprehensible in itself. I'll leave that with you to have a think about it. I suppose that just a further point to raise about costs is that it's something which can be raised at any point in proceedings. You don't need to wait until the end, on which point beware a draft order which says no order as to costs at the end of it, because that is a costs order and you can't get your money back for it. Appreciate that we routinely put that at the end of orders in private law children cases. Normally, well, sometimes I write it down and think, phew, nobody noticed that, but there's no comeback then. But it is something to just be aware of, that you actually do need to have costs which are recoverable, and clearly if they've already been dealt with by the court, you can't. How effective is this genuinely at flattening the course? Well, perhaps not very, because of course it is a question of it's a question of putting the genie back in the bottle, and this is something that I would imagine would only come up if things had already gone seriously awry. It's a very crude method of trying to deal with matters, often in the middle of proceedings when you've already gone on for a very long time, or you're right at the end. So the next way that we have of trying to ensure that people abide by what they're supposed to do so that you don't come back to court, because that is the other way of proceedings taking much longer than they should. So we're looking at enforcement and encouraging obedience, or does it in fact encourage obedience? So I've set out there sections 11J and section 11O of the Children Act 1989, but I just want to very briefly mention some other provisions which appear just above it, and that is sections 8H, which is to do with activity directions. So those are the provision within the Children Act that are aimed at helping, maintaining or improving an individual's relationship with the child concerned. And that's really looking at things like specific programmes or counselling that that person may need to undertake. I think that that's sort of a pretty interesting state of affairs, really, because the resources for that to happen now seem to have been completely decimated. I note that the provisions, these provisions within the Children Act were passed as part of the Adoption and Children Act 2006, which amended the Children Act 1989. They came into force in December 2008. 2 years after that, woo, austerity, and the gutting of a lot of the sort of the very broad net of support systems that were actually shoring up families who I suppose now might be considered edge of care, or who might have needed just that additional support system from an appropriate local service, a good charity, which was commissioned by a local authority, parenting courses. There's also the domestic violence perpetrators course, which I think, I mean, I can't remember the last time I did a case and there was something that was a specific programme that somebody could be referred to. That just doesn't seem to exist anymore in the way that it did 5, 6, 7, 8 years ago. And it is a great shame. We then have section 11I of the Children Act 1989, and that's the bit which contains warning notices, which are now just part of the format orders that we provide. Unclear really how effective a warning notice is at encouraging obedience. I don't know, in all honesty, how carefully people read court orders, and by people I mean lay parties read court orders, because it's just a big block of text.
It's just assumed in the heading, isn't it? I think that's...
It is. Yeah. And I suppose that the idea of there being a notice is that people should read it. But I do wonder in this day and age how good people actually are at reading through documents in fine detail. Realise it's there, it's bold, it's sort of right at the top of the order. But I sometimes have to point it out to clients when I'm taking them through orders to say, this is what this bit means. This bit's the recital, this bit's the notices, this bit's the order. By the way, that notice, you have to pay attention to it. I would suggest that, given the fact that orders are routinely not obeyed, that there's a question about how effective they are. But what they do effectively is that they enable section 11J, which is to do with the enforcement of existing child arrangements orders, to take effect, because you have that notice in the child arrangements order, you can't then say, oh, but I didn't know that there might be consequences. So section 11J. It's so interesting. I did a little straw poll of people within James to ask how many people had done an enforcement order application within the last year or the last 2 years. And typically people might have done the odd hearing here and there. It doesn't seem to be particularly prevalent, and I wondered why, because I remember when this came into force, how a lot of people thought, gosh, this is going to resolve a lot of issues. Now you're not going to have to use the nuclear option of a contempt of court application in order to secure compliance. And those did happen, by the way, for any young kids who might be here who can't remember the good old bad old days before section 11J, that did actually happen. But there are issues with how I think this works. First of all, because of course it comes right at the end of the proceedings. It comes after the end of proceedings, in fact. Secondly, because I would suggest that practitioners are often seemingly unaware of the fact that the test requires you to prove beyond reasonable doubt that a person has unreasonably failed to comply with the provisions of a child arrangements order. And that requires actually thinking very carefully about whether or not they had notice, the facts of the breach, the precise facts of the breach, and also in turn that person may well say, well, actually I did have a reasonable excuse, which, by the way, they only have to prove to the civil standard of proof. And it's thinking about things in that level of technical detail, which I think sometimes means that isn't so efficient.
Yeah, I think so. When we had talked about this, certainly in my experience, an enforcement application will often become a rehearing of the welfare, particularly if there's been a reasonable passage of time between the final order and the enforcement application. It's not
turns into a variation,
yes,
doesn't it?
It's not difficult sometimes to find something that's happened in the interim that provides the reasonable excuse. Is certainly the experience I've had.
Yeah, so you're caught between that. So the somebody really saying, okay, but actually I just want something different. And as soon as somebody turns up to court and says, well, yes, I do want this person to be punished, but actually I also want something different, the courts are going to leap on the and I want something different bit and just totally ignore the breach bit. The two things are really very different. And what is supposed to happen in enforcement applications is that you ideally prove your breach if you are for the applicant, and then you ask the court, okay, well, that breach having been proven, I want you to punish the person against whom the breach has been proven to the requisite standard. And I think that the problem is that family courts, their bread and butter day to day is to think about the welfare of children. They don't really see themselves as courts that punish. And it's a function which they are institutionally, I think, not really equipped to discharge. The whole point about enforcement is that happy families hasn't worked, and you need the court to effectively strong arm a reluctant party into doing what they previously have not done voluntarily. And when we're talking about enforcement, what orders can the court make? Well, they can order you to do between 40 to 200 hours of community service. It can also order CAFCAS, or actually invite CAFCAS to monitor whether or not the person against whom the order has been made is actually complying with that order. I'm aware, having read through the Public Accounts Committee's session on the 23rd of June 2025, so you don't have to, that CAFCAS is apparently very good at collecting statistics, much better than HMCTS is. One statistic I've tried to find for today and couldn't find is how many cases, in fact, they've done in which they have been asked to monitor the compliance with an enforcement order. But again, it's interesting that nobody is really looking at that anymore, and one wonders really what the point was of tinkering with the Children Act in this matter. Section 11.0, orders to compensate for financial loss. Well, obviously that arises from your proving a breach of the requisite standard and also being able to show that you have suffered a financial loss as a result. I don't know whether that makes anybody more or less likely to obey a court order. Again, anecdotally, it doesn't really seem to make a great deal of difference. Again, courts reluctant to engage with the question in the first place and wanting to deal with things in a much more consensual way. So the next point, again, looking at the end point of proceedings, discouraging parties from coming back. So that's section 9114, which all of you will be familiar with, which is really to do with the court's jurisdiction to prevent parties from coming back to court for a specific period of time and for specific application without its leave, which obviously need to be defined within the order. As you will also doubtless also be aware, section 91A has been introduced into the Children Act, and what that effectively does is that it lowers the bar for making section 9114 orders, and also the President published guidance in 2022, effectively making all the judiciary aware, by the way, section 91A has introduced a new lower standard under which you can consider this, and courts should be looking at this, not least because section 91A says the circumstances in which the court can make this type of injunctive order includes cases where the court feels that the child concerned or another individual is at risk of harm, and harm is couched really in very broad terms. Certainly in respect to the child, it isn't actually particularly defined anywhere. In relation to an individual or child over the age of 18, then it is physical or mental harm. It's not significant harm, it's just harm. And that, I would suggest, is sort of quite a broad category. Again, anybody getting to the end or towards the end of a children law case, a child arrangements type application, will know that judges routinely invite parties at the PTR to comment on and make submissions on section 91(14) at the final hearing. Now, is this really helping with the issue of delay? Well, I think time will tell, because that shift in the way that people have considered section 91(14) is relatively recent, but judges do appear to be applying it. Is it making anything faster? Well, President's guidance came out in 2022. I did a case in the CFC not all that long ago where we were given a final hearing listing date for 12 months' time, so arguably not that much. And again, problems that this does, it might keep cases out of the system, but is it a bit of a crude instrument? There might be a good reason for coming back, even if it's quite a short time after the making of a final hearing, and it doesn't really resolve the problems which might have arisen before. So this is a kind of order, you make it when you're really sure we've got this really good order, it's very soundly founded, it is going to work, we have now decided everything, go away, make this work, parents, because you're not coming back here, it's bad for you and it's bad for your kids. But that's sort of in the ideal system, isn't it? So this is, how do you stop people from coming back? And turning to the harm report now.
Yes, so I think one thing I was to say about that is that it's interesting how that then interacts with what we were saying about enforcement, which is, in an ideal world, you wouldn't need to come back and you should come back and enforce an order because nothing has happened in the interim. I think that's the thing, isn't it? You don't know what's going to happen after a final Children Act order, which is, again, inherent in the system.
Also, sidebar on the question of enforcement, how effective that is, how effective section 11 and sections 11J and 11O are going to a certain extent also to depend on what people using it, I suppose, first of all, and secondly, how effective the system is at dealing with those applications. And actually, they are just listed, it seems to me, in the same way that any other injunction is listed, and that means that things can take quite a long time to be processed. They're expensive to run, they take time, they're not, it seems to me, a particularly efficient way of dealing with enforcement in the current climate. And I suppose if you knew, well, it's going to take 4, 6, 8 weeks to get this done, you might be more tempted to use it. Doesn't seem to have been considered in any of the various pilots and initiatives that I read about in preparing for this seminar, and certainly isn't at all part of the Pathfinder, I don't think, for reasons which will become apparent.
So now we're going to just talk probably quite briefly about the Pathfinder. The reason that this quote from the harm report is on the slide is that it comes out of the recommendations for reform that were contained within that report. So if you want to really go into the background of why we are where we are now, that is one of the relevant documents. So this is, there are 3 what are called process maps in the most recent review of the Pathfinder Pilot that have been released by the government, and they are on these 3 slides, which I'm running through.
Yeah, you will get,
yes.
You will get these slides. They will be available in the next few days after. Indeed. So don't worry if the small script is making your eyes hurt.
Yes, and one of the reasons that I have run through them so quickly is I think actually it's this one that's probably the most helpful, and potentially the one before. In very broad summary, what the Pathfinder does is it triages quite aggressively, I think, at a very early stage as to whether or not where in the process that this needs to go. So what will initially happen is the court will look at whether or not there's an urgent issue that needs addressing. If there is, it will go straight to a hearing and the court will grapple with that. If there isn't, you then end up in the on the pathway that results in what's called a child impact report. Now, again, in very broad terms, what that represents is essentially the safeguarding checks plus a Section 7 report. So the CACAS officer preparing that report is speaking to the child in most cases. I should say at this stage that, of course, for those that practice predominantly in London and the South East, which I imagine maybe a number of you who are listening to this, It may not be something you have come across before. If you do practice in North Wales or Dorset, then you are probably highly familiar with this and have more experience of it likely than we do. So as I say, we're going through with a broad brush about what we think this is likely to do in terms of the system and some of the issues that we've identified earlier in this seminar. So as I said, that child impact report is section 7 plus, perhaps one way of looking at it. It also includes a dashed risk assessment. And what is, I think, relevant to what we've been discussing is that the CAFCAS officer is obviously doing that without having fact finding. So is doing the best that they can to analyse and assess risk without that agreed factual basis. What it also does is the report will make recommendations for a support plan to be developed and implemented in the event that there are allegations of domestic abuse made within that child's impact report. And what the most recent review does is set out the agencies that are commissioned to provide that. And they are often independent domestic abuse support charities or agencies, essentially, which links nicely back into the point that Eleanor made earlier about the availability of those services and their resourcing, which is unfortunately a reality of all these services in the system. So that is what will happen before, in most cases, the matter comes to court. Once the court has that child impact report, it undertakes an exercise in which it decides if it's going to go down the case management path or go straight to a final decision hearing. And in most cases, that again is not an attended hearing where that happens. That is an exercise the court is dealing with of its own motion. Now, obviously, there will be cases where this does really speed up the process and is very helpful. And those will likely be cases where there are quite straightforward issues of welfare, where the case may well have been able to settle itself eventually in the old process. And where that will result in decisions for children being taken much quicker and with fewer hearings and at less cost. So certainly there are real positives to this Pathfinder pilot, and particularly I think because you come to what may be the first hearing with a very clear and defined sense of what the parties' positions are, which if nothing else will likely make it easier to negotiate an agreed way forward. However, in the kind of cases that we have been discussing, where there are allegations of domestic abuse or of alienating behaviour, that case management path doesn't appear to differ that significantly from the way forward that was recommended, for example, in the guidance about alienating behaviour. You're essentially then setting the matter up for a fact finding. Again, you may get to those directions quicker than under the current framework, but ultimately you're then case managing in a very similar way with a more detailed report early on, but again, a report that may need looking at again once you've got an agreed factual basis. So how much that will assist in cases that are more complex and that are what we refer to as intractable, it remains to be seen. It also, the guidance doesn't deal specifically, insofar as I could see, with how it impacts if, for example, you need test round testing or you need a psychological assessment or anything that falls outside of the quite narrow scope of a clear welfare dispute about contact. No doubt that information will be gathered, but at this point, I think it's still fairly early days and it's not clear. So another question I think is interesting is whether or not it will meet its stated aims in respect of supporting survivors of abuse in family proceedings, because again, I don't think anything has got potentially, in our experience, to the stage where the outcome in respect of that issue is clear. So that's, well, as I say, quite broad brush.
Possibly. I mean, certainly the people who are presenting this as the solution to all ills when it comes to private law children cases say that the analysis undertaken of the pilot is that the feedback is good and that people feel they do have better experience with this system, focusing on the experiences of children and victims of abuse within it. There are a number of things that I think are quite interesting with this. It does seem to me that there's going to be sort of two tracks, so the straightforward cases and then the complex cases. But the early identification of complex issues is key. And that really depends on the quality of the gatekeeping, doesn't it? On the quality of the triage. And that, again, depends on who is making those decisions about which track you go down and what the issues in the case are. And the issue there is going to be with also with the quality of the reports that you obtain from CAFCAS, so those child impact reports. Because the reality is that we cross-examine Section 7 reporters all the time, and they do get things wrong. So I think that that's something that I'm particularly concerned about, because CAFCAS has to recruit another 200 social workers in order for this to be rolled out across the country. Well, who are those 200 social workers going to be? And are they going to be properly equipped to deal with this? One of the interesting points about the harm report is just that they raise the issue of misunderstandings that are institutional about things such as domestic abuse, that the knowledge that each person needs to have in order to make the system work properly and to ensure fairness and adequate protection and safeguards is patchy. And so I appreciate that we've got these new policy documents from CAFCAS, but that of course doesn't prevent patchy implementation. I'm just wondering what happens when you get a report which actually just isn't that good, because it happens all the time, we know that, and what the consequences are going to be. It also strikes me actually that this is a system which it's created really around the litigant in person, isn't it?
Yes, but I think a litigant in person who is going to have more difficulty than someone who's represented in challenging a report if they don't know the methodology or the guidance they should be following, and
or identifying, or indeed identifying the issues which are relevant, which they need to make the court aware, well, actually this thing has happened to me. And then I also wonder a little bit about the way that domestic abuse comes out in private law applications anyway, because even when somebody is represented, they sometimes can't say at the outset, look, all of these things have happened to me, as the realization of abuse. I mean, it can go into phases. When somebody remembers this other thing, they understand more about the abusive behaviour, and they realise, oh, but this is other aspect that actually I didn't tell you about, but that you should know about, and which the court needs to know about. So I wonder really, from that perspective, how good this system is going to be at protecting victims and being trauma-led, because that is part of the experience of trauma. You're not sort of very conscious of, hello, my name's Eléonore, let me tell you about every single aspect of my trauma because I've got a bird's eye view of what it all is. Sometimes it comes in drips and drabs.
Yes, so, and I've certainly had numerous conversations with clients where they've had that conversation with CAFCAS for the safeguarding letter, and they say, I didn't know that I was supposed to tell them that. I would have said that. I don't. And if actually, I think it may well only be one conversation for this child's impact report. There does seem like there is a real possibility that you might have a situation where the right questions weren't asked, or the amount of time it wasn't given, or it wasn't expanded upon, and suddenly you're back in a position where someone says, well, wait a minute, this is relevant. I haven't mentioned it yet, but here it is relevant to welfare.
So we're being quite smug about this, aren't we? Because really we're looking at this brilliant new initiative which is being trumpeted as the way forward, and we're saying, yeah, you missed a bit. The reality is that no system is perfect, and there are likely to be difficulties with it. But I do think that it sort of certainly shows a lot of promise for those cases where the lawyers might get in the way, frankly, because we all know that there are cases like that in a very, very straightforward case, which is being made extremely interesting and very complicated by lawyers who talk a lot and who make very simple things sound extremely complicated, where actually they're very straightforward. And the system gets around that by basically not letting them get in a word in edgeways for quite some time until the court has the case ordered in the way that it wants. And I think it's got to be right that those cases are not dealt with in a way which basically suits the lawyers and might yield to some of the instincts of certain clients who just want a case to last a long time, to be made as complicated as possible, driven by the enmity that they may have towards their former partner. So that's got to be a good thing. But I suppose that I still do think that this sounds like a way of trying to get cases out of the system, and not always for very laudable aims. The evidence that was given to the Public Accounts Committee on the 23rd of June this year made for sort of quite interesting reading. I mean, I obviously wasn't there. I read the transcript subsequently. You can find it on the internet. But the focus of that discussion was very much on getting cases dealt with faster. Also on public law cases being allocated more of the court's attention. There was an interesting question to do with capacity of the system, because the starting point should be, well, look, how many people do you actually need to get this system running? Like, what does, and the committee shall ask this, what does a good family law justice system look like? Instead of tinkering with bits and pieces, what do we actually want to achieve? What do you need in order to achieve that? At the moment, it seems that the focus is on getting cases out of the system, trying to get them dealt with more efficiently, yes, but for possibly a somewhat eroded value of justice, I would suggest. The reality of a system in which mostly people are representing themselves and having to go along with professional recommendations that they are not necessarily equipped to go behind or question in front of judges who are exhausted at the task of having to deal with litigant in person after litigant in person, is necessarily going to be that certain cases get dealt with very quickly or simply in a very dismissive way, because that it is just inevitable, and we all know that that is part of the system. And I think that the other interesting point here is that the court isn't entirely neutral in all of this. The court is also an instrument of policy in trying to get the cases in and out as quickly as possible, whilst also trying to meet the requirement of ensuring that the child's best interests are the court's paramount consideration. So I think there's an inherent tension there, clearly isn't being met at the moment within the system that we have. Just a final thought, and I'm sorry because I got extremely nerdy about this, but back in 2019, the private law working group did report back on how things had worked under the child arrangements programme, and they identified a number of issues, and they spoke to people working within the system, which actually, unlike the evidence of the Public Accounts Committee, directly included the experiences of lawyers and judges within the system, all of whom commented that one of the big problems was litigants in person and how much that had added to delay and to more hearings. Something which is completely absent, I think, from the way that people are considering this at the moment. They are looking at a system which has no lawyers in it, effectively. So watch this space, I think, when it comes to further reform. We live in interesting times. And a further thought, the Public Accounts Committee did actually say, well, it was in the newspapers last week, that it was extraordinary that HMCTS had inadequate data on which to base some of the decisions that they're making. That's to say that they had really no idea, based on the information that they collect, about where the delays in the system are occurring. And so there's this consensus amongst some of these government organisations as to what they think the problems are, but it's not actually based on hard evidence collected from the courts, because there is no one unified system to produce it. So the committee not unreasonably asked, but instead of having like all these different initiatives, Pathfinder is the main one that we've spoken about. There is this other thing called the DFJ Trailblazer Pilot, which seems to have, well, I mean, I was barely able to find any information at all about how that's been going. Apparently, it's been ongoing since 2024, and in certain areas of the country, but nobody really knows what's happened to it. And there are various local family justice boards that have all been tasked with finding action plans for how they're going to meet their targets for getting cases down. But there's no sort of person overall responsible for all of that. No metric for really what's being achieved. It sort of makes one wonder who's actually got a plan for getting the system working to the advantage of families, getting rid of the delays, whose imperative is something more than just getting the cases out of the system. Right, well,
Indeed. on that uplifting note,
let's have a look and see if we've got any questions that have come through. So somebody asked, did I hear you say they are doing a DASH risk assessment? Yes, you did. That is what they're going to do. We've also had a comment from somebody saying that CAFCAS are great at producing statistics, not so good at writing reports. Yeah, I mean, I think it's a resources problem as much as anything else. We then had somebody else commenting on the fact that cases quickly revert to variation of contact cases. I think that must have been around about the time we were talking about enforcement.
Yeah.
Yes, would agree. And the non-compliance issue is quickly forgotten. I'm afraid that we're going to have to man up and be a lot better at actually pursuing it, even though it is just a straightforward confrontation with no nice payoff of, oh, but it's for the sake of the children at the end of it. And then we've had somebody else going, I assume that the welfare principle doesn't apply to costs orders. As a solicitor, I strenuously avoid writing saying that I shall be seeking costs, particularly with unrepresented parties. Should I revisit this? Well, I think it's an interesting question, as we discussed. It's going to be a judgment call, and every case is going to be a bit different. But at the very least, it's something which possibly needs to be raised at court. If you receive a statement or a letter saying, well, actually, here's a raft of other stuff that I want to raise, and I've got all these statements that I want you to look at, then I think that the question at least needs to be asked and considered. Difficult to do that in correspondence. It would need to be nicely judged. Almost impossible to do against a litigant in person, who would feel very intimidated by that. But if somebody is represented, then I think it's something possibly to be addressed and raised in an appropriate case. And of course, bearing in mind what I also said about beware inadvertently committing conduct which is reprehensible on your client's behalf.
Other questions were the timescales for child impact report. So it's in one of those flowcharts. I think they're saying in North Wales it's currently 6 to 7 weeks for a child impact report, and in Dorset it's 8. So it is quicker than the 12 to 16 weeks that clearly someone has had experience of. And then we were also asked a question about saying if a child is not resistant themselves to contact with a non-resident parent, but the resident parent is refused to allow contact with a non-resident parent, does this meet the test of alienating behaviours? I think potentially not, because it's not the child who is exhibiting reluctance. I think that's maybe just a broader welfare argument as to this parent not being able to facilitate contact and meet their child's needs in that regard, if there are obviously no underlying reasons as to why that contact shouldn't take place. So I think it potentially doesn't fall within the definition of alienating behaviours, but it's still potentially a problem, is how I would perhaps put that.
Right.
So yes,
so I think that is in fact,
those were certainly all the questions that we know that we've had.
I'm just going to have a very quick look just to see if there's anything else. Something else. Any thoughts on improving QLRs? Huge delays when they don't materialise. Well, what can we say about QLRs?
Slightly outside the scope. I think they are within the scope, because
it's the causing of huge delays, because you turn up and they don't turn up, sometimes even when they have said that they're going to. Well, I suppose that the question is that you again need to start thinking about making application for wasted costs, I would suggest, in the short term. Maybe something on, I'm not a QLR so I can't say it, but I imagine that when you agree to be one, they will send you some form of contract, something which sets out the terms of your engagement, which I think probably, if it doesn't already, include the fact that if you're not able to fulfil the contract, that you may well risk a wasted cost order being made against you, unless you've got a very good reason for not turning up.
Presumably you're still regulated by
yes, absolutely.
So there's an ethical issue potentially.
Well, yes, but again, there is a question of people being willing to report. I agree that it's just not very satisfactory. It is part, of course, of ensuring that victims of domestic abuse, or people who it may well be have unfairly been accused of domestic abuse, are protected by there being somebody in the system who can ask questions in a neutral way, because they are not the alleged perpetrator. And so nobody can say that the alleged perp has been trying to intimidate, and the witness, if they are telling the truth, is not going to feel intimidated by the process. It's interesting, because I think it goes back to the consequences of LASPO and this situation that's arisen now, where if you allege domestic abuse in certain circumstances, you can have legal aid. But if you are the person against whom the accusation has been made, then you do not have a similar right, which I think is what we all knew was problematic when it was passed. It's a valiant effort. It's just a pity that the conditions of work are so poor that very few people will agree to do that kind of work. And I think that the initiative, such as it is, I don't know if anybody's been keeping statistics about this, but I mean, I've just never heard anybody say, "Oh, I had a great experience in a case with a QLR," either sort of a sort of part-time judge, full-time judge, or indeed any sort of legal representatives. I've just never heard anybody say that was a really great experience. I've never heard about it being spoken of in anything other than it caused huge delay. But I suppose, again, people like complaining, so you're more likely to hear about people's complaints than their successes. I don't know. I just don't think there's a straightforward answer to that issue.
No. Okay, so once again, on a very uplifting note, I think that is now the end of the seminar for today. Thank you all for attending. If you have any other questions, please do follow up via email, and that's to the events@42pr.com email address. There we go. A recording of this seminar will be available on our website and the YouTube channel in due course. And if you have any feedback, I can go to that same email address if you would like to give us any. The next session is taking place on Thursday, the 16th of October, and that's by Amanda Jepson and Charlotte MacDonald, and that will be a public law update. And so, yes, thank you again for attending, and that's it for us today.
Thank you so much.